So today we're dealing with the issues of Indigenous legal traditions and the criminal justice system. And this follows along from what we talked about last week in relationship to the overrepresentation of Aboriginal peoples in the criminal justice system. We saw many reasons for that overrepresentation, and we looked at many reports through many decades that paint the problem of the crisis in the criminal justice system. You'll also remember that this issue of criminal justice is quite closely related to the issues of child welfare, very closely related to violence against women. Of course, it's part of the entire dispossession that people face in relationship to their own governance structures, their lands, their territories. So even issues of Aboriginal title and treaties are relevant when thinking about criminal justice. One of the things that has been suggested through the years is paying more solid attention to Indigenous people's own values, laws, traditions in being able to deal with the conflict that they face. And that is presented as one potential pathway forward. That is, when people see themselves in the law, in the legal system, it may be that there would be a heightened respect for the law, heightened ability to follow and make the law in that instance. And so we start today with 4 frames that we're going to go through in the lecture. We're going to talk about law in Windigo. Windigo being a traditional Anishinaabe character that is consumptive, that is never satisfied, is never satiated, that hunger is always present. And often with Windigos, the idea is that they would take that out on those around them, that their consumptive behaviors would, almost like a vampire, take life from those around them. Obviously today we're focusing on the traditions around the Great Lakes, although Windigos are found across the prairies with the Cree people into the north as well, over in Quebec, even as far as Nova Scotia. So that's the first part, and there's a couple of cases that deal with law in Windigo. There's a case from the 1830s around the French River, and then there's a case from 1897 in Ontario as well. Following Windigos, then we'll look at Bearwalkers, another kind of character that can be both good and bad. And we'll look at a case that uses the Bearwalker character for thinking about self-defense and in relationship to criminal convictions. Then we'll look at the categories of Indigenous legal traditions and how this might be relevant to dealing with missing and murdered women, the theme that we talked about last class. You also have some readings that I posted from the Globe and Mail online. And then finally, the last part of the lecture today is reforming the criminal justice system, looking at sentencing circles, looking at the ii.R versus Moses case. So we're looking at Wiindigos, Bearwalkers, missing and murdered women inquiry, and sentencing reform. So that's the arc of the lecture. So we begin with this case in 1840, actually 1838, and it comes from the French River area of Ontario, which is just south of Sudbury on the eastern shores of Georgian Bay, not too far from cottage country, Muskoka, for those that know that part of the world. The person that was involved in this case is named William Jarvis. Jarvis was a superintendent of Indian Affairs in the 1830s. And one of his responsibilities was to help to facilitate relationships between the First Nations in the area and the colonial governments. You might recognize Jarvis. There's a Jarvis Street in Ontario. It's named in Toronto. It's named after him. This document was discovered by my cousin, Darlene Johnson, who teaches at the University of British Columbia Law School. And she was searching one day in the Toronto Public Library and came across this account. And I think I should read the account because it gives you a sense of the case law that was present within Anishinaabe communities, Ojibwe or Chippewa communities in this period. It begins as follows. An account given by Mayamaking of the murder of an idiot last winter by a band of Indians near the French River during the winter of 1838. So that's his preface. He begins the narrative. He begins the recitation of the facts. He came among us at the very beginning of last winter, having in most severe weather walked 6 days without either kindling a fire or eating any food. During the most part of this winter he was quiet enough, but as the sugar season approached, he grew noisy and restless. He went off to a lodge and there remained 10 days, frequently eating a whole deer at 2 meals. After that he went to another lodge when a great change became visible in his person. His form seemed to have dilated and his face was the color of black. At this lodge he first exhibited the most decided professions of madness, and we all considered that he had become a Windigo, a giant. He did not sleep, but kept on walking round the lodge, saying, "I shall soon have a fine feast." Soon this caused plenty of fears in this lodge, among both the old and the young. He tore open the veins at his wrists with his teeth and drank his blood. The next night was the same. He went out from the lodge and without an axe broke off many saplings about 9 inches in circumference. He never slept, but worked all that night, and in the morning he had brought in the poles he had broken off, and at 2 trips filled a large sugar camp. He continued to drink his blood. The Indians then all became alarmed, and we all started off to join our friends. So that's the facts of the case here. Right? This person who came amongst them at the beginning of last winter, so probably this time of year, late October, maybe into the early December period. And he was with them till the sugar season, which is usually around late March. So he's with them for 4 or 5 months, and he's obviously been invited there, and he's being observed by the community. And as this observation is occurring, they're seeing these increasingly growing dangerous, both to himself with self-mutilation, and then to others with the threats that he's making there, that I shall soon have a fine feast. So the issue is, what are they going to do to be able to protect this person from themselves and protect the community from this person who is exhibiting these characteristics of harm? So that's the facts. That's the issue. What are they going to do? So let's look at the legal process involved here. Again, the Indians all became alarmed, and we all started off to join our friends. A legal principle. The snow was deep and soft, and we sank deeply into it with our snowshoes. But he, without any shoes or stockings, barely left the indent of his toes on the surface. This person emaciated from a winter's starvation. He was stark naked, tearing off all his clothes given to him as fast as they were put on. He continued drinking his blood and refused all food, eating nothing but ice and snow. So, this couldn't have been an easy journey, right? They had to walk to go see their friends, and the snow was deep, and they would sink into it often. The month of March in Anishinaabe is sometimes called Onabanigisis, the hard crust on the snow moon. And if you have snowshoes, when there's a hard crust on the snow, you break through and you break your snowshoes. Sometimes it's called Makwa-Bimose, which is the breaking of the snowshoes moon. So this was not an easy thing to walk through this weather, to be able to, what's the next thing they do? We formed a council to determine how to act, as we feared he would eat our children. Decision in council amongst friends after long period of observation and aid, without seeming knowing what to do, it was unanimously agreed that he must die. His most intimate friend undertook to shoot him, not wishing any other hand to do it. After his death, we burned the body, and all was consumed but the chest. And I understand this next line, but you can read hundreds of Windigo stories from Ojibwe and Cree people, and they recount this line, which all was consumed but the chest, which we examined and found to contain an immense lump of ice, which completely filled the cavity. It doesn't make sense to us scientifically, biologically today, but all these accounts always talk about there's ice inside this person. The lad who carried into effect the determination of the council has given himself to the Father of him who is no more, to hunt for him, plant, and fill all the duties of a son. Imagine in our criminal justice system, if when the judge made a decision, and that had to be carried out, the judge actually stepped into the shoes of the person that was going to be incarcerated or going to suffer some consequences of the law. Right here, the lad who carried into effect the determination, right, the one that's administering the punishment here, has given himself to the Father of him who is no more. There's a restorative element to this justice, to hunt for him, plant for him, and fill all the duties of the Son. And then the rest of the people, you hear, we have also all made the old man presents, and he is now perfectly satisfied. I'm sure he wasn't perfectly satisfied. This was a huge loss in this one's life. But in accordance with the justice tradition that we're talking about, there was some sense of the acceptance of the will of the council amongst friends after this long period of observation where this person was taken care of. The father who lost the son was now taken care of. And then William Jarvis ends by saying, this deed was not done under the influence of whiskey. There was none there. It was the deliberate act of this tribe in council. So, here's a case. Again, you can read hundreds and hundreds, if not thousands, of these kinds of cases through the years as traders, missionaries, others encountered Indigenous peoples across the country, and in this regard, as Ojibwe and Cree people encountered, there's these cases about dealing with harm. And we've talked about some of the legal process that's involved here, the waiting and observing and collecting information, the meeting in council with friends when it is apparent something is wrong, the helping of the person, right, as they tried to do through the 5 months, who's the threat to the individual and the community. They help those who rely on the person, that's the father here, by restoring what might have been taken from them by the treatment. And there's both a collective and an individual element to restoration. Now, we all know, including Anishinaabe people know, that there are other causes for what happened here. This person obviously was suffering some form of severe depression, severe medical challenge. And so in the current setting, the response, the aid, the help that could be given would obviously take account of all we know about psychology and physiology and all the modern elements of medicine. But nevertheless, even though a different outcome would occur, we do not believe in capital punishment. As Anishinaabe people, most, I think, would say all Indigenous peoples would forsake as a collective, the idea of capital punishment in this day and age. But this was the time when other communities around the world were also engaged in this. But just because we isolate and say the result would not be something that we would pursue, does not mean that the process itself could not be relevant in figuring out how to deal with harm, conflict, challenge within the community. There's this case of Rodriguez that we have from our Supreme Court of Canada in 1993 on 1076. It says the way to resolve these problems, that is the legal process problems under Section 7 of the Charter, life, liberty, security, that's what's involved here in this community, the life, liberty, and security of people. The way to resolve these problems is not to avoid the historical analysis, but to make sure that one is looking not just at the existence of the practice itself, but the rationale behind the practice and the principles which underlie it. So we're not looking at the practice here of putting someone to death. We're looking at what is the rationale? What are the principles here that could be deployed to help in contemporary settings dealing with challenges around criminal justice, dealing with challenges of safety within the community. And there's quite a bit that can be pulled out here. In fact, there's a doctoral student at the University of Alberta who went to law school here, took this class about 6 or 7 years ago, Hadley Friedland, who's done a study of law in Wiindigok. And she concluded that there are a series of legal processes, steps, principles, obligations, and rights when she's looked at hundreds of these stories, when she synthesized this case law. Not just taking out one case like I've done here, right, but triangulating cases, digesting a set of stories, and finding what the common elements are. So what are the legal processes? There's a decision-making which is collective and open. There are also authoritative final decision-makers who are leaders, medicine people, and family members. She's identified steps, legal steps, in dealing with Windigos, recognizing early warning signs, as you see in this, at the beginning of the sugar season. If someone arrives alone with a disheveled appearance, if they're hiding, if they're ascribing supernatural causes to what they do, there's a cause there for concern, which leads to observation and gathering evidence to decide whether or not someone would fit within that category. And then there's a determination of the response, from kindness to care, to questioning, to healing, to separation, supervision, banishment, and death. Know that death was like the 1% of the possibility of what might happen when someone becomes Windigo. Most often when someone exhibited this kind of behavior, there was the kindness, the caring, the questioning, the healing, or the separation or the supervision. Right? This occurs along a spectrum. It's not just a knee-jerk reaction, either or. There's a choice about how people can act with their legal tradition to try to overcome the problem that they face. Sometimes people want to jump to banishment. Most tribal courts, tribal entities in the United States, as you know, they exercise inherent sovereignty. They have criminal justice authority. They have tribal courts and tribal codes. They can enact laws dealing with banishment if they want. Most all of those tribes have said, we're not going to use banishment as a remedy. And they certainly don't use death as a remedy. They then kick in with these other elements of their system, the supervision, the separation, the healing, the questioning, the care. What are the principles here? How is healing done? There's a lot in the cases that, even in this case, that tells you about that. What's supervision? There's a collective element to that supervision. How do you deal with separation? What's incapacitation? What is retribution? Note that you can have retribution. Indigenous legal traditions are not all about restorative justice. Although they can be a lot about restorative justice, they are not all about that. They're also complex human systems that have at their disposal the range of potentialities. There's obligations here that the community and the individuals have towards the person that's charged or observed to be a Windigo, which is to help and protect, to warn others about this behavior, and to seek help. And sometimes this person might need help their entire life. And some of the people that Hadley worked with have taken on a lifelong of supervision trying to assist someone who's found themselves in that state where there's great potential for harm, and they act that that harm has been diminished because of the obligations of others. There's a due process here. There's a protection for the accused. Right? You can't just rush to judgment and do what you want with that person. There's a right for that person to be heard. There's a right for the family member to be involved in deciding. There's the life, liberty, and security interests of the individual in these instances. And of course, when we take this into contemporary settings, Indigenous peoples don't just find what's persuasive, what had happened once upon a time. You know, we interact with what is the jurisprudence around life, liberty, and security. How might that help us as we deliberate, as families, as friends, as close people? There's a right to be helped, this right to ongoing support. Those helpers also need reciprocity because of the burden that they bear. And there's this last point, being open to everything that's available. Most of these people in this study didn't see courts as necessarily foreign. They certainly saw them as not often being responsive to them, but sometimes you would turn to courts for aid in this. Again, if you're not creating a romantic, pre-contact, isolated tradition that has, you know, separated from the world, then you would turn to courts. You would turn to the healthcare system. You would turn to the police. In this case, a lot of people turn to Christianity as well. Despite residential school, there's quite a strong tradition of Christianity that's often syncretic in Indigenous communities, where they take those teachings and they try to blend them with their own. So, one possible way of dealing with challenges in criminal justice is thinking about the role of Indigenous legal tradition, not just through one story, but through an entire worldview, synthesizing, working on creating law that the people themselves can identify with. Any comments or questions there? Yes?
Yeah, I really love how in Hadley's work, one of the animating questions she used was, how do we protect those we love from those we love?
Great question. That's what she talks about as one of the issues that's identified in these cases. How do we protect those we love from those we love? Right? Sometimes the violence isn't necessarily stranger to stranger. It's uncle, aunt, cousin. We love them, but there needs to be protection there as well. And so this way of proceeding, we have an Indigenous Law Research Unit here at UVic that their job is to work through these issues as they're doing through about 30 or 40 communities across the country. Yes?
I was wondering, do you know if there, like, because one area that seems like it's, you know, within the Indigenous legal tradition is going to be, like, going forward probably be pretty important would be how they would handle a situation where there's kind of cross tribal boundaries.
Yes.
You know, say a Windigo that harms someone from another tribe or vice versa.
Yeah, so how do you deal with disputes that are intersocietal, right, that are between maybe the Anishinaabe and the Cree, or Anishinaabe and someone who's from another country just recently involved. In the United States, with the tribal court context, they have what's called full faith and credit or comity arrangements, where the judgments of the tribal courts can be given force in state courts. Sometimes that's done just as a matter of course through constitutional principles. Sometimes that's done through negotiations, as the justice system of, say, the state of Wisconsin would negotiate with the justice systems of the First Nations in Wisconsin, and they would come up with a scheme that they would then follow to know when the others' decisions would be given recognition in their regime. There's also like hot pursuit provisions. So, you know, if someone commits a wrong in one jurisdiction and is like on the tribal reservation and is fleeing out into the state, there's the ability to be able to pursue that person and arrest them, or vice versa if it's the state going into the First Nation. So there's creativity that can be worked out in that regard. Negotiation is often the case. Now this is the criminal justice context that we're talking about Wiindigos. But Wiindigos are not just individuals who threaten to take others' lives. Might a Windigo be another kind of consumptive, cannibalistic behavior that takes the life out of the land? Might a Windigo be a mining company, an oil and gas development? Might it be the greed of someone in a commercial transaction as they bleed dry the person that they're taking advantage of financially, right? So it is possible to think about these legal principles not just being applicable in the criminal justice context, but in the Aboriginal title context, in the treaty context, in the consultation context. Finding the rationale, the principles underneath the behavior. If you don't just focus on the practice, what might those principles be doing today if we could fully give them place to help their revival? Another case in the materials that deals with Wiindigos is from 1897, the Ontario Divisional Court, Machekequonabe. Machekequonabe. This is a case of people that were set outside of a camp of Indians guarding that camp because they knew that someone was out there wanting to cause them harm. They had made a judgment. We are not given what that legal process was that led them to that judgment, but people are stationed with rifles watching for a Windigo. And someone draws near and they call out 3 times, ask them to identify themselves. And this person that's being called out to does not identify themselves. So there's this threat, there's not a response, and so someone uses the rifle, and as that person flees, who's not answering, that person is killed by one of those guards. Turns out it's a tragic situation. It's a foster son who's killed his foster father in the belief that this person was a Windigo, the person that they're standing on guard for. And again, we're not given the legal principles here that this community followed through. We're just given a really truncated Western view through quite racist lens. A pagan Indian is the way the court starts, who, believing in an evil spirit in human shape called Windigo, shot and killed another Indian under the pressure that he was a Windigo. And the question is whether or not this person being shot in this way could be a self-defense to the charge of manslaughter. There was no intention to be able to harm this person. And in law at this time, if you had a religious belief in something that caused you to do an action, that could be a defense of man, of self-defense. So you get this being raised, this idea of self-defense by the defense counsel. And the court rejects this defense and says, upon the case reserved, if there was evidence upon which the jury could find the prisoner guilty of manslaughter, it is not open to us to revise the finding. The finding being that there's culpable homicide without justification here. It's not a justification that this person the guard killed someone who thought this other person was a Windigo, even though there might not have been any criminal justice presence in the territory, in this area where it was occurring. And so therefore there's a finding that there's a conviction of manslaughter here. We've got all the facts, the defense. Yeah, evidence supports a finding of manslaughter here. So this illustrates, I think, that there is at the least not an appreciation of the operation of a legal system, a system of order, of authority, standards, principles, measures for judgment. At the least, this case shows that there's a failure to recognize Aboriginal justice. At the most, it shows that there is some kind of recognition, but it's judged, that is, the Indigenous system is judged as being pagan, as being savage, in the words of the court here. And the consequences of this, of course, like the consequences in the Chilcotin case, like the consequences in the Riel trial, there's not an ability here to be able to bring these standards of judgment to bear. It's just like in the Aboriginal title context. It's as if Crown sovereignty comes along and wipes out all the social ordering of the people that were there prior. When you wipe out a people's social ordering, it's no surprise that they become challenged with issues of law and order, peace and order. It's no surprise that we have a crisis in our community because the criminal justice system has not replaced itself as a system of law and order that most Aboriginal peoples respect on the ground. And yet our own systems have been highly fragmented as a result of this assertion of sovereignty. You know, it's as if these things didn't exist. So that's the law and Windigo context. Then there's the law and Bearwalker context, the next set of cases. As I mentioned, Bearwalkers can be good or bad. Makwa-Bimose is what we say. This is a practice of medicine that can be helpful to people. It's also a practice of medicine that can be harmful to people. There's a story that's told in this book, Bearwalker and Other Stories, by Basil Johnson, that elder who passed away in September, who helped me along in my life a lot. He told this story in this book, which goes as follows. There was a young man that wanted to learn how to be good in the world. He wanted to learn how to practice good medicine. He wanted to be helpful to his fellow human beings. But he didn't quite know how to go about doing it. He wanted to be a good bear walker, but he was stumped as to that path. And so he started talking to people within his communities and asking who he could trust, who he could go to be able to provide this kind of guidance. And eventually all the replies came back, for the most part, pointing him to this one elder, this one individual. And so with this guidance, this young man, wanting to be good, took some tobacco and cloth, went to an elder, to this elder that he'd heard about, and said, gave him the goods. Can you help me? Can you help me to know how to be good, how to practice good medicine, how to help serve my fellow beings? And the elder thought, because it's not an easy thing to ask of someone to be able to article you, basically, over a long period of time. And so in thinking, he said to him, that is the elder, said to the younger person, rest assured, it will not be easy. If you pick up this commitment, I'd like you to stick with that commitment. It's not easy. The young man thought about it, but quickly answered back, yes, I will do it. I want to be good in this way. So the old man accepted the tobacco, accepted the cloth, and took him on as an apprentice. So one day, they're walking out along the river. And as they're walking along, the old man says to the younger man, look in the river and tell me what you see. So the young man looks down in the river, and he looks up and says, I don't see anything. The old man says, no, you have to look closer, and tell me what you see. And so the man kind of bends down, the younger man, and looks in the river, and all he can see is just the water flowing past. Comes up and says, I don't see anything. Again, no, look closer, tell me what you see. So the young man this time crouches, gets close to the water, tries to take it all in, stands up, I don't see a thing. Old man says, okay, that's okay. And they go along their way. The day passes, they eventually go home, they're sitting in the old man's house, and he says, do you remember earlier in the day when I asked you to look in the river? The young man says, yes. Do you remember what you said? Yes. I didn't see anything in that river. The old man said, you were right. You didn't see yourself in that river. So the young man tweaked a little bit to what he was saying there, but was frustrated with this way of teaching. It seemed so indirect and so disjointed from the time the experience happened to actually getting the lesson. He was frustrated. Again, you go through this kind of way of being in the world for a little while. Some weeks, maybe even months pass, and one day they're along another river, and the old man says to the younger man, you see those beautiful lily pads over there? I'd like you to get me one. So the young man walks down to the river, and just along the shores is going to pull off one of the lily pads with the beautiful white flower on the top. And the old man says, no, not that one. I want that one way over there on the other side. Do you see it? And the young man looks back, are you kidding me? But he says, no, okay, I signed up for this. And so he says, I'll do it. And so he walks through the river, and it looks really beautiful at first. It's all shining with the sun and the waves. It looks like diamonds in some respects on the water. But as he goes through the faster part of the stream, he eventually comes to where there's a bit of a brackish backwater, where there's a lot of these lily pads growing. And he calls back to the old man, is this the one you want here? And the old man says, no, I want the one right on the far edge. And so now this young man is wading through this gross water, just full of algae and flotsam and jetsam, and it stinks. And he looks back to the old man and says, is this the one you want? And the old man says, yeah, that's it. And he's about to break off the plant at the top there where the pad is with the flower. And the old man says, no, not that way. I want the whole thing. And so the young man, stands there. His head's just barely above the water. It's just gross as could be. And he's trying to pull at the root. And he just can't get any torque. He's not properly situated. And he says, how do I do this? And the old man says, you're there, you figure it out. So he tries some more, but he's just not able to pull it out. Eventually, he recognizes that if he's going to get this, he's going to have to dive under that water. And so he dives down into the root, and he tries to, in the dirt, to pick out that root, holding his breath. He's not able to do so. And when he comes up, he's just covered in crap. And he looks terrible, and it smells terrible, and he is disgusted with himself and disgusted with what he's standing with. And he looks back to the old man thinking, I can't believe that he's asking me to do this. But nevertheless, he goes down again, and he does this time after time until eventually he's able to pick the root out of the soil, under the water, and he holds up the entire plant with the root, the stem, the flower. He says, is this what you wanted? And the old man says, yeah, that's it, bring it towards me. And so this young man then comes through this water, just covered in junk, through the fast water, onto the shores, eventually hands the plant to the old man. And he doesn't say a thing. The old man is silent. And And the young man thinks, this guy is disrespecting me. He's not teaching me. He's very slow to give me lessons. I quit. I give up. And so he goes his separate way from this old man. Years later, though, this young man has grown himself, and he's sitting at home. And he goes, oh, because of what he's learned, that's what the old man was trying to teach me. Which is sometimes when you set on a task, it looks so beautiful. Like the diamonds on the waves in the sun. When you set out a course of learning, it just looks like everything is going to be just covered with beauty. But sometimes, if you want to get to the source of healing, to the source of power, you have to dig deep. Because actually what the medicine man wanted was the root, because that's where the medicine's found. It's called the kundamo in Anishinaabe one. That's where the preparation for the healing occurs. And man didn't realize that at the time. And he saw in this a metaphor for what he needed to do and had missed earlier as a lesson in life. That sometimes you have to figure it out yourself after a period of observation and training. And though it looks beautiful, you might have to dive deep into that crap to be able to pull up something that's helpful by way of offering it to a community. So this idea of Bearwalkers here helps you appreciate how you can tilt on the nice edge in terms of whether or not you go towards something that's good or something that's harmful towards others. And this Makwa-Bimose, this Bearwalker story, is another case. Interestingly, about 10 years ago, after I'd been telling the story for maybe 5 years before that, so I've been telling the story for 15 years, about 10 years ago, a woman said to me, I know who that is. I said, what? Yeah, I know who that young man is. I said, really? Yeah, she said, that's my father-in-law. Who is that? His name is Harvey McHugh. He, big academic in the 1960s, early 70s in education. He was the head of the James Bay Cree Education Society. And June McHugh said, this is my father. June McHugh was teaching at UBC Law School. And I taught her partner, Duncan McHugh, when he was in law school as well. You might have heard of Duncan McHugh. He was a reporter for CBC News. This is Duncan McHugh's father. So sometimes you actually get the connections of the story coming back to you, even like this story, right? Not understanding everything all at once, but the legal lessons can sink in later. So that's one story of Bearwalkers. Any questions or comments about that? So now we have another story of a Bearwalker, which is the Queen versus Jacko case out of Manitoulin Island in 1997. And here you have someone who's killed the victim. His name's Tab, a 45-year-old man who's a heavy drinker, who for some months before this altercation went around saying, I don't know, I just feel like killing someone. I don't know what is wrong, I just feel like killing somebody. Something big is going down. And this guy, who was eventually killed, Tab, was obsessed with bad medicine. He went north to be able to learn how to be a Bearwalker, but not to apply it in the good way, but how to get to others, how to cause them pain and harm and regret. And he and the defendant, Leon, were drinking one day, and heavily drinking. Tab was found to have 400 milligrams of alcohol in his blood. Leon was found to have 100, exceedingly drunk. And people sitting down in the community heard up on the top of the hill something that sounded like bears fighting. And they know what bears sound like fighting. this is what they thought was going on, was bears fighting. But then they started hearing cursing, and they recognized it wasn't just bears, someone was in an altercation. At that point, this young man comes down into the community and says, "I'm a warrior, I got the Bearwalker." He was emotional and screaming. He said, "I won the victory." He put his hands up in the air. "He won't bother us anymore." And he talked about the protection that he had offered in that regard. Now, the person that was killed, the person that was purportedly practicing bad medicine, was a big man. This accused was very slight, shy, quiet, small in stature, frail, physically very weak. When the person that was killed was drunk, that person was an angry person as a drunk. Here, when the accused got drunk, he was never a fighter with that. And so the question is, given that one person thought they killed another person for being a Bearwalker, is whether or not there can be a defense, self-defense, excuse here that excuses the charge. And the court looks at the belief of the accused here about being a Bearwalker, looks at the belief of the community, and finds that there was self-defense. Or at least finds that there was not an intentional killing here beyond a reasonable doubt. There was enough doubt, given that there was no eyewitnesses to the killing, given all the discussions in the community, there was enough of a reasonable doubt to prevent this person from being convicted of murder. So, serious, serious case. Now, I think it's important to pause at this point and recognize the positive elements, which are here as a recognition of an Indigenous way of looking at the world and understanding aspects of potential reasons for why people are behaving like they are. That's good. But let's problematize this. This could be a real detriment to communities. If people just stand up and say, "I'm a Windigo," or "that was a Windigo," "I'm a Bearwalker," or "that was a Bearwalker," you could literally have people getting away with murder by feigning a sense of their beliefs here, or having that sense, believing that they're a Bearwalker, or the other person's a Bearwalker, or a Windigo, the other person's a Windigo, and then putting it towards the court system in a very thin way, without having all that Hadley Friedland identified there, in the complexities of the circumstances. People could use Indigenous legal traditions in a way that takes us further away from order, further away from peace. Indigenous legal traditions are not the answer to everything at all times and all places. They can be and could be as much a part of the problem if they're picked up without context. If they're not practiced with all the checks and balances that you would expect in that way that Hadley put the information forward. And so the reinvigoration, the restoration, the resurgence of Indigenous law cannot be done in a very thin way, in a very decontextualized way. It has to take account of greater context like this. Let me problematize this one more time, which is to tell you a story about someone who was the most respected figure in my mother's life as she was growing up. I think I told you about my grandfather before. Great man, wonderful ideas, very smart. But he was someone who was challenged with alcoholism in his life. And so for periods he was absent from my family's life. He's the guy that went down to Hollywood, became a Hollywood Indian in the 1930s, and that's where my grandmother actually met my grandfather, and she made him that bonnet there because she would sew for the movies in the 1930s, and she would dress up her eventual husband. That's their life together. And they eventually came back to the reserve when Pearl Harbor was bombed in 1941. Because if you looked visibly not Caucasian, you did not get jobs in Hollywood in that period. You faced a lot of racism. So he packed up Grapes of Wrath style in this old truck, loaded all his family on the back, and they cruised across the continent in this jalopy until they arrived back on the reserve. And my mom was 4 and grew up from that time forward on the reserve. But her father sometimes got into these challenges. And so this man, who I'm partially named after, Charles Jones, my name Giganos. Charles Jones was a loving, kind, thoughtful, helpful chief of the community and would give you literally the shirt off his back. Here's another picture of him in this loving surrounding. So imagine my surprise when I came across this story, which troubled me in relationship to all that I knew about him. This is from my aunt, Wiindigok, some oral history about Charles Jones's life. Some Indians knew bad medicine, which they sometimes used to bring misfortune to people they disliked. They were also the Makwa-Bimose, or Bearwalker, which was used to control a person's mind or destroy a person, completely killing him. This is a form of voodoo, this is Aunt Irene's language, and a very powerful witchcraft, which was widely used years ago, but don't find much today. Now this is on the bad side of bear walking, right? We know from that story I told you, there's a whole other side. The priests and minutes of the churches condemned the use of all Indian medicines and made the people burn all their herbs, good or bad. Now I think I might have told you before when I was doing my LLM thesis, it's called a genealogy of law, looking at 7 generations of my family and how they had been challenged by government officials in relationship to their own ways of life. And I discovered this to be true. All these medicines were burned. People were asked to just get rid of their ways of healing. Fortunately, some priest, some Jesuit in the community, copied out 150 pages of Ojibwe medicines in Anishinaabe. So when I was doing archival research, oh, what a treat that was to be able to find all of those sources. But here Irene is talking about the pressures in the community to get rid of them. 2 elderly women had worked all summer gathering different kinds of medicines to do the bear walk. The priest went to these 2 women, members of its church, and told them they must burn all these medicines or they would go straight to hell when they died. They were frightened. As the priest watched, they brought out all their dried herbs, barks, and roots, piled them up, and the priest lighted a fire under them and destroyed their summer's work. Incidentally, Charles's mother was one of these medicine people. So he grew up in a medicine family. And speaking of the bear walk, there was an Indian medicine that when sprinkled about, the bear walker witch couldn't step over. My father once caught a witch. He was a young man at the time, lopping along a woodland path when he saw in the distance a light that flashed on and off. That kind of story of lights flashing on and off, something we wouldn't talk about today. I grew up with those stories. I don't know if they were ball lightning that were along the escarpment or phosphorescence from old cedar trees and swamps, whatever. But this light flashing on and off, he wouldn't have ascribed it to a ball lightning or a piece of wood. He knew immediately that it was a witch coming along the woodland path which was coming towards him. He quickly stepped behind a large cedar trunk. The witch was in the form of a large black dog, from whose mouth fire spurted at each breath. As it passed his hiding place, he jumped onto it, immediately changed to its form a young woman, completely naked, except for the dog's head tied over her head, dog's feet tied to her hands and feet, and the skin of black fur hanging down all over her back. The Indians believe that in this transition from witch form, the witch is very fragile and vulnerable. My father had thrown his arms about the black dog and grabbed him from the back around the rib cage. The witch, a well-known woman, was trembling in fear of her life. When asked where she was going, she immediately told my father, a strong young man, that she had been on her way to see Mrs. Black, who was very ill. Asked if she was a witch who was doing the Makwa-Bimose or Bearwalk to Mrs. Black, she admitted that she was. She asked Charles, my father, to let her go as he was hurting her ribs, and she was very weak. He made her promise to leave Mrs. Black alone and go home. As he released her, she quickly disappeared into the dusk, and Charles went back home to tell his father what had happened. His father said that this woman was the witch, would be very sick for a month. This was so, and the story was told that she had fallen on some rocks and broken numerous ribs. This is a gentle man. This is a kind man. But here we've got the following of a tradition that caused this woman harm. Complex, complicated ways of working through this. The rushing to judgment that governance and Indigenous law will solve everything is got to be more nuanced than that. I worry about how some people might use this, again, if it's decontextualized, particularly when women are continuing to be vulnerable given the way that they've been displaced from positions of leadership, from land, from status, the violence that we talked about in the last class. So what do we do with that? What we do with it is we don't just take it as gospel, right? Those pieces of information have to come into a human community and be deliberated about. And they have to be compared and contrasted against things that are more generally occurring in the society around us. And sometimes what's occurring in the society around us will be rejected because it's more harmful than what might be within the society. But sometimes it's the traditions itself that will be rejected. When you receive tradition, you have agency, you have choice. There's the opportunity to decide, yep, that works. Nope, that doesn't work. Up and down the coast here, people practice slavery. No one practices slavery anymore. Right? Traditions have been abandoned, even as other ones survive. Now, we've got this issue of missing and murdered women. And I wonder about applying Windigo and Bearwalker principles, ideas to this. There was a round table from the Native Women's Association, organized by the Native Women's Association of Canada, about 10 months ago, where they talked about what would be required to be able to ensure that people are in safe positions, particularly women, within communities. So they identified principles, human rights. If we talk about Indigenous legal traditions, if we talk about dealing with missing and murdered women, we have to talk about rights to life, to security, to equality, to be free from discrimination. Those don't have to be foreign concepts for Indigenous peoples. They can be foreign concepts. They can be applied in a very decontextualized way. If you just took the jurisprudence from section 7 or 15 and said, oh, here you go, community, fill your boots, live by Canadian law, that's not going to work. But if you say, we know you have principles of equality, life, liberty, security, let's examine how those can be enhanced, protected, strengthened. And if that occurs, byproduct is you also get the advancing of the charter or the human right, not necessarily through the jurisprudence of section 15 or 7, but through another kind of an approach, this kind of approach that respects human rights. Secondly, the idea to note that it's a shared responsibility across governments, across communities. It's not just one person like my great-grandfather, my great-grandfather. You can't just as one person stand up and decide to take law into your own hands. That is contrary to all of those things that Hadley collected, But sometimes you get that occurring in First Nations communities, people setting themselves up as the authority that can be unquestioned because they have some kind of special spiritual insight, they're from a hereditary family, they speak the language, they were raised by someone who is respected. There's all sorts of reasons that people can set themselves up in that way and claim that the responsibility is theirs and not a shared responsibility. It has to be community-based in terms of this dialogue from the round table. Community-based and led, recognizing the diversity of community situations. Right? Recognizing there are schools of thought within a community. That just because people don't coalesce around one consensus doesn't necessarily mean you don't have law. We have law in Canada, but we have a majority in Parliament, and we have an opposition. We have law in Canada, sometimes we get a majority decision and a dissenting opinion, or sets of dissenting opinions. But we still have law because we found ways to be able to ensure that dissent can occur within our legal order. And likewise, within Indigenous legal traditions, we need to allow for appropriate dissent. It has to be community-based, diversity of community situations, and appropriate support given to building community capacity. This can't just be done on the back of some envelope or some grant one time from an organization. You can't run any kind of system in that regard. It has to be focused on healing, improving relationships based on respect and understanding amongst Indigenous and non-Indigenous communities, and the need for holistic approaches. What I'm talking about here is how do you develop Indigenous legal traditions today? And this dialogue really brings out appropriate legal processes here. And collaborative. Indigenous peoples must be partners in developing and implementing responses to addressing violence against women. Remember the point we made before, that often the people that are subject to the violence know more about it than you and I would. And they would have some, not all cases, but they would have in some cases the insight as to what would be necessary to help them through that situation, or others that might be in their circumstances. And then behavioral change. It requires a shift in attitudes by society and behaviors. It requires a shift in societal attitudes and behaviors within individuals, institutions, and organizations, including men and boys, who this dialogue said are key change agents. This isn't just an Indigenous woman's issue, it's a Canadian issue, but it's also an Indigenous man and boys issue as well. The dialogue also talked about issues of prevention and awareness, raising public awareness aimed at changing attitudes. I mean, I'm wearing this little patch here that Barbara gave earlier in the year, all semester, to show the need to keep this front and center in terms of the harm, recognizing the educational tools that are around us, reducing marginalization by improving socioeconomic development and outcomes. This connects now with the child welfare class, with the Aboriginal women class. It connects even with the federalism class. Section 88 gets in the way of doing some of this stuff. It improves prevention responses within intimate family relationships. Community safety. Why do not Aboriginal peoples themselves have responsibility for the safety of their members? Sometimes you say, well, we can't trust them because they're part of the problem. It is true. They are part of the problem. It is true they can't always be trusted. But if you've got proper support and structures in place, you can build that trust. And then the policy making and justice responses have to be with people like you and I. Lawyers have a role in this. Other professionals have a role. That is, the justice system is not just going to go away in this regard. And then the question is, what would you add? Right? If we were advising a First Nations community, or if we were advising the federal government about how you might reinvigorate Indigenous systems of decision-making, dispute resolution, standards for judgment. There would be this, that this dialogue came up with, but you've now had an entire 3 months of classes. Hopefully some of those insights would also come to your aid so that you don't feel helpless as you walk away from this class. You're recognizing there are tools that are present. Questions or comments there? So we've gone through Wiindigos, we've gone through Bearwalkers, we've gone through a contemporary process here addressed at dealing with those who are cannibalistic, consumptive, sucking the life out of our community, sucking the life out of individuals. And now we have another kind of model of reform, which is the sentencing circle process. Again, not a panacea, not to be universalized, not without critique and need to weigh it carefully, recognizing all that. A very positive, prominent, important action that can be taken to help people if proper safeguards are in place. Stress. If proper safeguards are in place, this way of dealing with people that have offended and have been found guilty can lead to better outcomes. In Ontario, in Toronto, there's something called the Aboriginal Legal Services of Toronto. There's other organizations like this across the country. They're urban, Aboriginal-based organizations with community boards of volunteers that, again, are people like these, often law students and lawyers and community activists, social workers, elders, that if someone gets in trouble with the law, there's something called the Gladue Court in Old City Hall, and they can be diverted to community house. And sometimes one of those diversions can be to the Aboriginal Legal Services of Toronto, and in that setting, people can be sentenced, or they might be sentenced in the Gladue Court, but then the sentence itself is supervised by this community council. And when that occurs, the rate of recidivism, the rate of recurrence of crime, falls dramatically. I don't have the figures in front of me, I wish I did. But say the regular rate of recidivism, this is just hypothetical, is like, people go back 80% of the time and just recommit crimes. If they go through one of these councils, it's only 20% of the time that they get involved with the law again. And you think, how could that be? Toronto, right? That's a big, impersonal, seemingly non-Aboriginal place. Well, it isn't a Ojibwe place, it's also a Haudenosaunee place. I know it's an Aboriginal place, but it's seeming non-Aboriginal space. Why does it work there? Because often, one of the reasons that people get off the path, there's no one from their community to hold them to account. There's no one to express a sense of support. There's no one to come to their aid when they're down and out. And these councils, by sitting with an elder and a law student and a social worker, and they work out a contracted plan. This is what you're going to do over the next 6 months or a year. And it's not what you're going to do. We're going to figure out what you should do. They get to have feedback into figuring out that plan. And then by following that plan, they actually connect their identity. They actually connect to a community. It might not be that they connect to their home community, but for the first time, as this Philip Moses case demonstrates, there's an opportunity to receive an expression from people in the community about how what they've done, the thing that they've done is harmful, impacts others, etc. So, you might be Blackfoot from southern Alberta, living in Toronto, sitting with a Haudenosaunee, Anishinaabe, Mi'kmaq person, and yet through this plan, things can be presented that to help you through. Questions or comments about that? Yes?
I got to observe the voodoo court they've got in Brantford over the
summer.
Okay.
And that was really fascinating to see how the circles work. And very separate jurisdictions. So in Ontario, I only know of the Ontario ones, have been implementing them or are working towards implementing.
So this is an example of sitting in Brantford this past summer and seeing the circle sentencing operating in that regard. I know there's I think it's called a First Nations court in New Westminster in Vancouver that operates with some of these principles.
So just to clarify, these Aboriginal courts and neglected courts, they function in parallel with the traditional system or afterwards, or where does that fit?
Yeah, it's a good question. Where does tradition fit within these gladiator courts or sentencing circles? They're very much a part of the mainstream criminal justice system. Sometimes you can get a pre-charge diversion and end up at something like an Aboriginal Legal Services of Toronto organization. Sometimes it's post-charge, but before going to trial. Sometimes it's after you've charged and convicted, and it's at the sentencing moment that you'll be sent to these. So it depends on that particular structure. What I'm saying here is that if you follow these processes that were outlined in the NWAC roundtable, you get Aboriginal peoples involved using their own decision-making criteria and skills. It helps to enhance that way. That's not the only way to proceed. Next class we'll talk about separate Indigenous justice systems that are run by communities, not necessarily run by the mainstream structure, but this is very much as run by the mainstream structure.
I was just going to comment on the court in Westminster. It would be, they would have to plead guilty and then be sentenced in Westminster. If they're convicted and found guilty, the sentencing judge, the judge that found them guilty is seized. So it's rather limited in terms of who would actually be convicted.
So this is the court in New Westminster. They would have to plead and plead guilty before the process would kick in for that First Nations court.
So this is an Ontario process, but it's a Yukon territorial court is Makwa-Bimose?
Yeah, so what you have is innovations taking place across the country in most jurisdictions where they are blending mainstream with Indigenous participation, but you don't just get Indigenous peoples participating and then accepting full scale what the justice system does. They bring their own values to bear, their own principles, their own stories, their own worldviews. So here, this is a Yukon court that's initiating this, but this has been picked up in other jurisdictions. Justice Barry Stewart was actually an LLM student of mine when I was at the University of somewhere back in Ontario. After he was a court on the bench, a judge on the bench of this court, he came and did graduate work. And the ideas have been picked up across the country. Other comments here? I think it's interesting the way he frames this case in terms of what courts often like for not just Indigenous peoples, but others. It says in quite a critique, among the great predator groups in the animal kingdom, often placed secure by each member of the site they rest or hunt, significantly influences their ability to control group decisions. In the criminal justice process, arguably one of contemporary society's great predators, the physical arrangement in a courtroom profoundly affects who participates and how they participate. The organization of the courtroom influences the content, scope, and importance of information provided in the court. He says, by reorienting just even the structure of the court, you can have ways of facilitating greater participation of others. Yes?
So note on the recidivism rates, I think that the drug court in the downtown east side of Vancouver, the recidivism drops about 50% when people participate in a drug rehabilitation program instead of going through normal criminal punishment. So I don't think those numbers would be far off.
Yeah. So that's a great point. The recidivism rate drops about 50% with the drug courts in Vancouver. if there's a participatory element, as we're describing here. Thank you. Other comments? So that's it. Next class is our final class. We'll be dealing with Gladue, Ipili, and separate systems of justice. And we'll see you Wednesday.